Legal dictation 80 word per minute. Start. A short reference to the factual backdrop would be expedient to appreciate the matter properly. Stop the petitioner, in discharge of his legal debt liability, issued one check of rupees 75,000 in the name of the opposite party dated 8/6/2001. Stop. The opposite party presented the check to his banker for encashment on the next date, but it was returned unpaid on 13/6/2001 with an endorsement referred to drawer. Stop. The opposite party contacted the petitioner, who requested the opposite party to present the check again. Stop. The opposite party presented the check again on 29/3/2001 for encashment, but it was returned unpaid from his bank with an endorsement insufficient of fund on 3/7/2001. A demand notice was sent by the opposite party to the petitioner through his lawyer on 18/7/2001, but the petitioner failed to make payment within 15 days from the date of receipt of the demand notice. Stop. Accordingly, the opposite party filed a complaint for prosecuting the petitioner under Section 138 of the NI Act. Stop para. Mr. Pratik Bhattacharya, learned counsel for the petitioner, contended that the learned courts failed to appreciate the evidence in its proper perspective and came to a wrong finding that the check was issued by the petitioner in discharge of any legally enforceable debt liability. Stop. He has taken this court to the deposition of the complainant, especially his statement in cross-examination, and submitted that the complainant admitted the fact that the writings on the check, exception the signature, was not of the petitioner. Stop. He further submitted that in the petition of complainant, detail of the alleged loan taken by the petitioner has not been mentioned anywhere, but mentioned only for the first time while the complainant was examined. Stop. The learned courts, Mr. Bhattacharya contended, were incorrect to believe the statement of the complainant. Stop para. I find no force in his submission. It appears to me that both the courts had taken the contents of the petition of complainant and oral testimony of the complainant together with the documentary evidence in coming to such a decision, which, in my considered opinion, reasonable, prudent, and result of proper appreciation of the facts, circumstances, and evidence on record, and is not required to be upset. Stop. This court is not oblivious that in exercising its revisional jurisdiction, this court is not opposed to further reappreciate the evidence already appreciated and reappreciated by the learned trial court and the learned appellate court. Stop. In exercising its such power when invoked by a convict challenging validity, legality, and propriety of a concurrent findings of fact, High Court's power is restricted to as to whether or not any fundamental principle of law has been violated, resulting in gross miscarriage of justice. Stop. In the case in hands, no such principle of law has been violated. Stop. Therefore, this court is reluctant to interfere into such findings by exercising its revisional jurisdiction. Stop.